And welcome back to Contract B. This is video 2 for topic 7, discharge by termination. And let's get back to our prezi. Okay, so we've looked at the whole issue of being ready, willing and able to perform. We've had a look at unwillingness and refusals to perform, erroneous interpretation. Now we come to the issue of being unable to perform. And in order to get across the line, to actually show that someone's repudiating for being unable to perform, you need to show that they were wholly and finally disabled from performing, and it's only really at that point that you can say there's been a repudiation and that you can accept that and terminate. And here we have the almond investors and koala tree nursery case. We had a contract for 90,000 one-year-old almond trees. They had to be at least 90 centimetres high, and the delivery was to commence on the 1st of June 2007. So bearing in mind that we have this contract for relatively immediate delivery of a whole heap of saplings, almond tree saplings. Now, if almond investors wanted to actually keep some of those plants in reserve, it was able to do so under this contract by keeping them in the nursery, and Koala Tree Nursery undertook to keep those plants growing away quite happily if almond investors paid an extra $1 per tree for whatever trees they wanted to keep in reserve until the next planting the next year. Both parties here knew that if the average almond tree gets to about a year old and they're not about 90 centimetres high, then there's going to be problems with that tree. It's going to be more susceptible to disease and death and problems and so forth. So that's not what the purchaser wanted to get. Now, the first delivery was made on time. However, some of those trees were rejected for quality reasons. Nevertheless, an invoice was sent to the purchaser for about $96,000, as you can see there. The purchaser was kind of a bit nonplussed, hadn't been stellar performance to date, and then all of a sudden they get this email saying, oh, sorry, I know that we have to deliver the next lot of almond trees, but we can't do so. What we will do is we will give you some of the one-year-old trees as promised, and the rest we'll make up with some fresh plantings. More than 20,000 of them were to be made up with fresh plantings in 2007 when this was all going on. And they said, but don't worry, you know, even when you want them in 2008, when they're a year old, they'll be 90 centimetres high by then. Now, of course, that's not what the contract actually required the seller to do. There was an immediate delivery there date of 1 June 2007, so certainly not correct performance there. The purchaser terminated because the seller was unable to perform. They had an inability to perform, and it was held, yes, despite this rather valiantly made argument by the seller's barrister that tried to suggest that the fact that they were able to keep some trees in reserve meant that they could make up any shortfall with later planted saplings was incorrect. And so the termination was valid by that email indicating that they were more than 20,000 trees short. The seller was, in fact, wholly and finally disabled from performing according to the terms of that contract. So that's a fairly clear inability to perform. So here we come to anticipatory breach. So we've had a look at repudiation by unwillingness to perform. We had a little look at refusals to perform, erroneous interpretation. We had a look at inability to perform, and now we're down to anticipatory breach. And that obviously occurs when something's gone wrong in anticipation or before the actual time of performance. And here we have the case of Foran and White. Classic case, you know, there's meant to be a right-of-way registered for a block of land. The block of land is meant to be settled on a particular date. What was it? 22nd of June. On the 20th of June, so a couple of days beforehand, the vendor contacts the purchaser and says, look, sorry, can't register this right away in time, won't be able to settle on the 22nd. Now, at that point, the purchaser has two very clear courses of action. They may rely on their common law right to accept that repudiation and terminate straight away, or they could wait until the actual date for settlement had arrived and passed, and then terminate for the actual breach. And that's exactly what they did. So they waited until the 24th of June, contacted the vendors and said, sorry, look, you didn't settle on the 22nd of June, as you said, therefore we're going to terminate the contract and claim our deposit back. And the vendor says a very important thing here. The vendor says you can't terminate now because you, yourself, purchaser, didn't turn up to settlement on the 22nd of June. You did not show that you yourself were ready, willing and able on the date for performance of that particular obligation. And that was a live issue because if you are going to accept someone's repudiation and terminate, you yourself must be ready, willing and able. You can't be in breach yourself and then try and accept someone else's repudiation and terminate. And the court had a good hard look at this, looked at the differences between anticipatory breach and being able to rely on your common law right to terminate for anticipatory breach. And then noting that when that non-performance continues up to and past the date for actual performance, it will become an actual breach. And they said the purchaser had no real obligation to accept the repudiation on the 20th of June. They were quite within their rights to wait until the date for settlement had gone by and then terminate for the actual breach. Okay, well, they go into a kind of long-winded discussion about why this was so, but they say basically if the vendor's communication to the purchaser that they would not be able to perform on the proper date indicated to the purchaser that it was pointless for them to go ahead and turn up to settlement with a cheque and all the documents ready to hand over, and they knew the other party was not going to be there, that would be pointless. So they said no, when there has been an intimation like that, the purchaser knows or the other party knows that it's pointless to perform, well then, unless they've been notified that somehow the other party is magically ready to perform on time and they have to get their act together, then they in fact don't have to turn up to settlement. The other party doesn't have to perform on time if it would be pointless. And that is foreign and white. And now we need to have a little look at the whole issue of election to terminate. And so what we've seen is that you have this two-pronged course of action. You can either accept straight away a repudiation and go ahead, rely on your common law rights and terminate then and there, or you can do nothing. Now in foreign and white, they said repudiation by the other party won't automatically end contract. The innocent party has to actually go ahead, make the election to terminate for that repudiation, accept it, and communicate their termination of the contract. Now, if a repudiation goes unanswered, that is, if the innocent party decides to do nothing, then the contract stays on foot. All of the contractual rights survive. Effectively, nothing happens. It's like, that never happened. Now, if the anticipatory breach continues along right up to and past the actual time for performance, then that anticipatory breach crystallises into an actual breach. And here we have the case of Sargent and ASL. Very important case to get your heads around. I would strongly recommend reading it online. It's not terribly long, but excellent discussions of the relevant principle here. Again, we have another contract for the sale of land. Prior to completion, everybody had to work out whether this particular parcel was affected by some road widening. Now, the contract provided that if it was, either party could rescind. No real problems there. I mean, it's a fairly typical kind of term. The vendors knew that the land was affected, and they let the contract go ahead after the date for 2.5 years. They accepted various different payments of interest, instalments of principal, increased rates. In fact, the vendor and purchaser both got together and sought that this particular parcel of land be brought under some specific legislation. So there'd been a great deal of cooperation between the parties here. And then at that very late point, the vendor tries to terminate. And the question was, did the vendor elect to affirm that contract despite having a right to rescind? And the court held yes, obviously. They had affirmed and they couldn't rescind. Once an election like this had been made, it can't be retracted. So you can't say you're going to affirm the contract or do something like this, accepting payments, do something that would exercise your rights under the contract and therefore indicate that you're going to keep it on foot, and then all of a sudden go, oh, no, sorry, I actually want to terminate. Have a look at this judgment, particularly of interest. Have a look at what they say about the relationship between making payments in a situation like this and the doctrine of estoppel. Nice little confluence of principle there, things that we've been discovering this particular term. Now, the requirements of an election to terminate, obviously you need to have knowledge of the facts that give you the right to terminate. That's pretty much a given. There is some debate in the case law about whether or not you also need to know about having a legal right to terminate for the conduct that's occurred. Usually not, and particularly not in cases where there's been things like fraudulent misrepresentation or something like that, and then a subsequent breach. Usually the court will say all you really need to know about is the facts that give rise to an election to either affirm or terminate. Then you've got to indicate by unequivocal words or conduct that's consistent only with one of those two options. Either you're going to accept the repudiation and terminate, or you're going to keep that contract on foot. You're going to affirm the contract. Okay, as I said before, it doesn't have to be by words, it can be by conduct, like, for example, accepting payments. The last thing, a substantive thing we need to cover is time. And wow, there's a lot of discussion about time in the textbook. I'll leave you to explore that at your leisure. It can kind of be summed up in a relatively brief fashion, actually. At common law, basically, all of the time stipulations in a contract are going to be construed as being of the essence, that is, an essential term in the contract. However, for equity, it's the absolute opposite. So for equity, time stipulations in a contract are never going to be of the essence or conditional. Now, there are three different ways that the court deals with the various different kinds of time stipulation or non-stipulation in a contract. And firstly, you have the situation, very common, particularly in land sale contracts, time is expressly of the essence. The contract actually says time is of the essence, they're the magical words, and you've stipulated a date. Now, obviously, if that's the case and that time stipulation is breached, then you're going to be able to terminate, no problem there. Gets a little bit murkier as we go along. What happens then if you have a date specified for a particular obligation to be performed, but the contract doesn't say those magical words, time is of the essence? What happens then? Well, in Lewinda and Lace, which we'll talk about in just a second, they said in that situation, if the contract has actually gone to the trouble of specifying a date, once that date has come and gone, you can actually serve a notice to remedy that breach and to perform whatever obligation it is within a reasonable time thereafter. Now, if the other party does not follow that notice and that reasonable time comes and goes, then there's going to be breach of the time specification in the notice, and you'll be able to terminate there. It's a very interesting discussion they have in Lewinda and Lace about this issue. And they say, well, if the contract has actually specified a date, why should they have to wait a reasonable time and then serve a notice that allows another reasonable time to perform? No, we're going to say that if there's a date specified, even though it's not expressly of the essence, once that date's passed, you can serve your notice, and then the other party just has that one reasonable amount of time to comply. If not, you can terminate. The situation's more difficult when it's what we call an open contract. So there is no particular date or time specified for performance of that particular obligation, and time is not of the essence either. So it's all a bit grey and murky. Here you do actually have to serve your double reasonable time periods. Okay, so you've got to wait until the original contract would anticipate a reasonable time had gone by for performance of that obligation. Then you can serve your notice to remedy your breach, and that notice to remedy breach must allow another reasonable time for the other party to actually comply. So that's the issue of time. Let's have a little look at Lewinda and Lace. Here, again, another contract for sale of land, signed in November 79. No time fixed for completion, time's not of the essence there, open contract, okay. Within 28 days of the vendor delivering their statement of title, the purchaser had to send their transfer docs to the vendor. Now, the vendor answered the requisitions on title and issued their statement of title at the end of November 79. And then the parties had a bit of a dialogue. They agreed that settlement would occur in January 1980. Okay, no specific date, just January 1980. Got to 13th of February, and the vendors are getting pretty annoyed. The purchasers hadn't even sent their transfer documents, even though the vendor had given their statement of title in November. They then gave the notice to complete on the 13th of February, and so you must complete within 21 days. If not, then we'll consider that the contract is going to be at an end. Now, the time for compliance came and went, and then in April, the purchaser sought to complete. And the vendor said, oops, sorry, that 21-day period's already come and gone. Sorry, contract's at an end. We're keeping your deposit. And obviously the purchaser wasn't too happy about that. Runs off to court. What happened? Well, the purchaser in this case, having borne in mind the delay only from January 1980 to the 13th of February 1980, hadn't left it an unreasonable time to perform. And so that meant that the notice itself was not effective and the contract was not terminated. So the purchaser could actually get their specific performance. They didn't lose their deposit, and the purchaser anyway certainly went away happy. So that is Lewinda and Lace and the issue of time specifications. You need to allow that reasonable time if you have an open contract. A reasonable time from performance, you then serve the notice, and then you need to leave another lot of reasonable time for compliance. So notices to complete. Well, what do they have to do? Pretty easy. You've got to tell the other party what they have to do, when they have to do it, and what's going to happen if they don't do it. Now, the last one's fairly important. You don't have to say, and we will terminate if you fail to comply with what you must do and when you must do it. You just need to say a couple of magical phrases. If you get one of these two, you're pretty home and hose. You either say that the time fixed for performance is of the essence, Or you say, in the event of non-compliance, we will consider ourselves as entitled to terminate this contract, or we will consider ourselves entitled to treat this contract at an end. Something that will signal to the other party the seriousness of this notice. And that was exactly what, unfortunately, the solicitor did not do in the Lorinda and Capalaba Park shopping centre case. So they said there, it appears reasonable that our clients require your client to complete registration. Remember, they had to have this lease stamped and registered within 14 days. If registration is not completed within that time, our clients naturally reserve their rights in respect of your client's default. Now, as I said before, in the trade, that's kind of a shot across the bow. You kind of know what the other party's saying, but for the court, in terms of the seriousness of the ability to terminate in these circumstances where the notice is the thing that gives you the right to terminate, it has to be absolutely crystal clear to the other party what's going to happen if they don't comply. And so that notice was ineffective to allow termination. But, as I did say also before, there were various things in the factual matrix there. The assurance that they would sign and stamp and register the lease, the fact that they didn't, the fact that the lessee had asked a number of times for this to happen. A 9-month period went by, and even at the end of that 9 months, the lessor's solicitors really didn't indicate that anything was going to get done. All of that together constituted a repudiation, because you could tell that the lessor was just not going to perform. It was a refusal to perform. So that's notices to complete. And the last little final piece of the puzzle for us this week is just some other various stuff. How exactly do we terminate? Well, obviously, if there's something in the contract that says you must terminate by serving the other party a notice, and that notice must specify 30 days to rectify the breach, and if that's not communicated or if that's not complied with, you may terminate. That's what you're going to have to do. I mean, you had a look at the A-Man aviation case last term. Horrendous mistake there, not following the contractual provisions properly, and therefore the termination was ineffective. Has to be clear and unequivocal. So pretty much with all this stuff, if you're going to accept a repudiation or if you're going to actually turn around and terminate, it's all got to be clear and unequivocal. Consequences, just to recap from the beginning of this video: your future obligations are discharged. You can still sue for damages, and we'll pick up that thread in a couple of weeks' time. You can recover the contract price if what you've done has been fully earned and accrued prior to the date of termination. So things like deposits, you will have to pay even though the contract has been terminated. Instalment contracts are a little bit different, and particularly here where you've got land sale contracts, because all of those instalments are gradually, accruing towards an overall payment price for the conveyance of the land to you. If that conveyance of the land doesn't occur, then you're going to be able to get your instalments back, but not your deposit, as I said, obviously. So that's the other mishmash of various different things to consider, and that is death of a contract by termination. And like I always say, if you have any queries or questions, just shoot me an email, send me a message, post something on Facebook, and we'll clear it up for you. But until then, I hope I get to see you in a Zoom sometime soon. And that's it for this week. Thanks. Bye, guys.